Good morning, everybody. Thanks for the introduction. That's taken about half of my starting off points away. So as was indicated, I'm actually a lawyer, so you may be wondering what exactly I'm doing here, because most typical lawyers don't really know anything about IT. And I noticed as Andreas was speaking, I have the proof of that because I have bits of paper for my speech and he had a laptop. So I think that points out the difference. What I am here to do is tell you about some of the consequences I've dealt with as a result of data breaches. And to actually Andreas's point, in interacting in those situations with all the techie folk, there was very much a learning curve from their point of view as to what I was getting at, and also a learning curve for me as to where they're coming from, how they've set things up, and all that kind of thing. So I really think this intersection of policy and, in my particular focus, consequences is super important when you're putting the whole thing together. And as Andreas commented on one of the questions at the end, it's kind of, it's the lawyers here and, the CS people and the coders here, and we just need to get a lot closer together. So the point of this talk is really to sort of run through the consequences, but also some of the reporting requirements to show you how kind of what the guys in the trenches with the actual sort of coding and computers, what's going to be important. So the first thing I did when I was asked to do this talk was try and figure out, like, what is the difference between cybersecurity and data protection, and kind of where do they interact? So basically, cybersecurity covers safety against cyber attacks, and data protection covers a set of issues related to data storage management and access. The access part of it is largely about where the cybersecurity comes in, because it's unauthorized access that cybersecurity is basically targeted against. So cybersecurity has a stronger focus on protecting the system itself, and the data protection legislation and the policies that have to be put in place to comply with the legislation are all going to be aimed at safeguarding personal data which is stored in that system. And it's all going to be driven by various regulations. So you've got HIPAA in the US, you've got GDPR in Europe, and here in Cayman, we've got the Data Protection Act. So let's start with, what data are we protecting? When you're designing a system, you've obviously got to know, what is it I'm trying to actually ensure is going to be properly protected. And what it is personal data, which is a super wide category. It's basically information about an individual. Couldn't really get much wider than that. And to give you some examples, it's employee files, your email histories, the history of the post to your favorite social network, record of your bank transactions, more seriously, your medical records, and also some personal data is actually said to be sensitive. So that is actually even more important, and the consequences for it getting out to the bad guys is even more important. And sensitive data is probably what you might imagine, but it's genetic and health data, information on racial or ethnic origins, political opinions, religious or similar beliefs, sex life, and commission or alleged commission of offences. So that is what we are protecting. So what are we protecting it against? Well, the goal of data protection is to protect the privacy of the individuals concerned, but also strike a fair balance with the legitimate interests of the entities who need to use the personal data. And there's a lot in the legislation about the word processing, and processing in its broadest term is holding data and using it in any way that's going to mean the data protection law applies, which is a bit kind of circular. But just really obtaining, recording, and holding data is processing it. Carrying out any operational set of operations on it is processing it. Organizing it, adapting it, altering it is processing it. Retrieving it, consulting it, or using it is processing it. Disclosing is processing it, etc., etc. So pretty much, if you have some information on people and you hold it, or you use it to do payroll, you are processing data. So the data protection principles, and these data protection principles, these are the ones that are in the Data Protection Act in Cayman, but they come out of and are sort of common with the European and the UK standards. So GDPR, and now that England has left the EU, they've got their own legislation, but it's basically GDPR. And our Data Protection Act was based on the UK law before GDPR. It's not massively different. The principles are the same. There's just a few little things that we're talking about. So the data protection principles are fair and lawful use, purpose limitation, data minimization, data accuracy, storage limitation, respect for the individual's rights, security, integrity, and confidentiality, and then international transfers. You'll be very glad to hear that all we're going to really focus on today is the security, integrity, and confidentiality. That is obviously, or the most obvious way I should say, that cybersecurity comes and interacts with data protection legislation and requirements in any organization. And I should just say that who has to comply with this is basically everybody. And that's governments, that's organizations, that's not-for-profits. Pretty much the only person who doesn't is you on your little home computer. Anybody else, pretty much you do. And when I say on your home computer, sending emails to your friends, doing things on a personal level, not working from home. So I had to put this slide in because data protection policy, this is the three monkeys with the see no evil, hear no evil, speak no evil. And it's kind of a summary of a data protection policy, but obviously it's going to have to be a little bit more detailed than that. So looking at security, integrity, and confidentiality principle, what is it that you are actually required to do in terms of protective measures? And this one goes a little bit into what Andreas was saying in terms of, risk meets a sort of ability to comply, cost of compliance, etc. And what the legislation uses is the word appropriate. You have to use appropriate technical and organizational measures against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. So there's a few different aspects to the principle. There's the organizational measures, staff training, policy development. There's the technical measures, physical protection of data, I can't say this word, pseudonymization, say it slowly, encryption, and then also securing ongoing availability, integrity, and accessibility, backups, that sort of thing. So again, cybersecurity meets data protection. When you come into the technical measures, there's an element also of, obviously when you're designing a system, you want to make sure that what you've got on there is going to be kept there in the form that it was originally given to you. But we classically think of cybersecurity protecting the data from the outside. So, what measures are actually going to be appropriate? Well, you're going to have to review the personal data you hold, the way you use it, and you're going to have to assess how valuable, sensitive, or confidential it is. Now, remember we had that sensitive personal data. How much of that have you got? If you are a hospital, pretty much everything's going to be sensitive personal data. If you are something like a not-for-profit, you may just hold addresses, names, email addresses. That's personal data, but it's not necessarily sensitive personal data. So that's going to feed into what are your appropriate measures that you're going to be taking. You're going to need to take account of factors such as the nature and extent of your organization's premises and computer systems, the number of staff you have, the extent of their access to personal data, and whether you have anybody that is actually doing data processing on your behalf. There's concepts in the legislation, which I'm not going to go into in any detail, but you've got the data controller, who is really the person who originally has the data. And then you have data processing, which is anybody who's actually doing something with the data in accordance with the slide. Those might be 2, 3, or more people. The data controller is actually responsible for all the data processing, even if that's going on in a third-party vendor or something like that. So what is appropriate has to take that sort of thing into account, as well as, of course, what information you're looking at as well. So what is a data breach? A data breach, or a personal data breach, it's a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. Now, what's interesting about this, again, is there are scenarios that you can think of. We're all classically thinking about the hackers have come into the system, they've stolen all the data, maybe they're holding you to ransom, otherwise it's all going up on the internet, something like that. But equally, it's a breach if your backups fail and it's all gone. Equally, it's a breach if somehow it all got corrupted and everybody's date of birth got changed by 5 years. Equally, it's a breach if you lost it for a bit, but then you got it back. So, let's say backup from last week failed, but you managed to go back a month and all that data was the same. You would have lost it for a bit, even though you'd actually managed to restore it. All these things are data breaches. So if you have a data breach, what's going to happen, or what do you have to do then? So you've got a duty to report all personal data breaches to the ombudsman, and this is in Cayman. The ombudsman in Cayman is the regulator for the Data Protection Act. He does other things, but in this particular context, he is the person to whom reports are made. The Ombudsman actually has a really good website. The forms for reporting are on that website, and lots of guidance about what you need to do, when you need to do it, etc. But the other thing about this is, you might be expecting, okay, there's going to be a regulator, we're going to have to report to the regulator, that makes sense. But actually, you've also got to report to the individual whose data was breached. And that is often actually the more sensitive issue for organizations. Most people are like, hey, we report to regulators all the time. No worries. But you mean I've actually got to go out and tell my best client that I revealed, their bank account details to somebody? That's where people go, ooh, do I really have to do this? Um, the other thing about this to know, and this is very important to communicate to the techie teams, you've got to do this within 5 days. This is not 5 working days, this is 5 days. Now, one of the interesting things is hackers know this. So it is not a coincidence that you tend to get your, we've got your data, it's all going on the internet, unless you pay us a gazillion dollars, on a Friday evening, because they know, you've got to scramble. You going into the weekend, you've got to call the whole team in. You've got to figure out what the hell's going on here. And you've got to get your lawyers on board or whoever it is you use for reporting. And you've got to get all of this done in 5 days. It's actually worse in some other jurisdictions because it's 72 hours. So count yourselves lucky in Cayman, you've got 5 whole days. And there's a lot of stuff you actually need to know in order to do your reporting. You've got to provide the ombudsman and the individual with all the information about the breach, but also you've got to provide them with the information about the measures you've taken and the measures you recommend any individual to take. And indeed, because 5 days is not normally long enough to get your arms around the whole problem, the measures that you intend to take, the ongoing addressing, what you've not been able to find out so far, what you will report further, when you will report it, etc., etc., etc. So all that to say, you need robust detection, investigation, and internal reporting procedures in place. And this goes back to, I really think, what Andres was talking about, which is you've got to build that into your system, I think. If your system isn't geared up, and the people who designed the system didn't know what you were going to need to know when you were going to be reporting, it's going to be quite difficult to kind of reverse engineer that, in my experience. It's like, oh yes, we can get it, but it's going to take us 10 days, that's, and you can report that, but it's not terribly satisfactory. The things that you have to report when you fill in the form, you've got to provide a description of the nature of the personal breach. So, what is it? Was it loss? Was it destruction? Was it unauthorized access? Those specifics. You've got to provide a description of the consequences of the breach. Has this appeared in public? Has it simply gone to 2 or 3 people? Is it a ransomware situation? The measures proposed or already taken to address the breach. So, this is, oh, we just changed a few passwords and that's going to do it, or is, there are a whole bunch of, have you had to go and employ, detectives and crawl agencies to try and find, where the stuff's gone to and all that kind of thing. So there's an awful lot, believe me, there's an awful lot to get your arms around, to understand from, your technical people. And, what you have typically in this situation is, your CEO, your CIO, your lawyers, and a bunch of computer people sitting in a room, none of them speaking the same fundamental language, all trying to understand, what's happened, how can they stop it, and what's happened is often super difficult in itself to figure out. So yeah, that's one of, I think, my major messages really from my experience is, if you have these conversations before something happens, how are we going to know this? How are we going to know the other? It's just going to be super helpful when you actually come to the reporting. There is an exception to reporting, and it's what I like to call the no harm, no foul exception. And it's what's referenced on the slide here, where the breach is unlikely to prejudice the individual's data rights and freedoms. That was the 7 principles we talked about earlier. And then just by way of an example, one of the things that most commonly happens, which is a data breach, is you send a document to the wrong email address, or you send an email which includes somebody who's not really supposed to have got the email. Um, you can reach out, if you reach out to the person who received it, and you can get a confirmation that they will destroy it, they didn't take any copies, etc., etc. Usually that will fall into the kind of no harm, no foul principle. That's really common. I am my firm's Cayman data champion, and I can tell you I probably get asked that 3 times a week at least. Another example is about deletions. So the example that I sort of copied out of somewhere, the university experiences a breach because somebody's accidentally deleted all the alumni contact details. As I mentioned before, the details are later recreated from the backup. That's actually unlikely to affect any individual's right to have their data processed fairly, to have it minimized, to have it deleted upon request, etc. So that's the kind of breach that doesn't need to be reported. And believe me, this is not entirely a plug for my profession, but I would say, if in doubt, do ask somebody to give you a professional opinion on it, because as we'll come on to, consequences of breach and consequences of failing to report a breach even more are pretty serious. So just quickly, I might be sort of teaching everybody to suck eggs, but really I'm focusing on the malicious data breaches that are going to lead to a reporting requirement. I'm not really going to focus on the no harm, no foul. I mentioned it to be complete, but that's not really what this is about. And it's because malicious data breaches mostly result from cyber attacks, hence cybersecurity to prevent us from cyber attacks. And as you probably all know, what we're really talking about here is phishing, the brute force attacks, and malware. And I probably don't really need to go very much into that with this sort of audience as to what exactly those things are. But essentially trying to stop all of those things happening is cybersecurity. Unfortunately, most people would now tell you it's not going to be if you have a successful cyber attack and a data breach, it's going to be when. And you need to report that breach 9.5, if not 9.9 times out of 10. If it's a cyber attack, you're going to be reporting it. It's very hard to come up with a situation where there's no harm, no foul there. And as we've said, you're going to need to do it quickly. And so this is where your security systems should ensure that they totally enable that to happen. So the last thing I'm going to talk about is kind of, does this really matter? So yes, on very, very, very many levels. So we've all, had in the news, people like Uber and Equifax and so forth. And I'll talk about a couple of examples of fine situations at the end. But, for a business organization, obviously a data breach can have devastating effects on the reputation and on the financial bottom line. I read some statistic that the average cost of just investigating, reporting a data breach on any sort of sizable organization, which I think was 100 staff and above, is something in the region of $4.2 million. So it's not cheap. And that must feed into when we were talking earlier about what is appropriate. You know, your CFO, if nobody else, is going to care that, all right, you're asking me to spend an extra $1 million this year on this system. If anybody's giving you pushback, wave some of those cost of breach statistics in their face. For government organizations, obviously, compromised data can mean exposing highly confidential information to foreign parties and very, very bad actors. And for individuals, identity theft is a huge problem for them. And, we've all sort of heard of the dark web and everything that's going on the dark web, and the sale of data on the dark web. This all goes beyond and is much more serious than Facebook harvesting your likes to sell to advertisers. So failing to notify a breach when you're required to do so under the Data Protection Act in Cayman is a criminal offence. And it can result in a conviction and a fine of $100,000. I will say that in Cayman, the monetary penalties are probably the least of your problems, unlike in some other jurisdictions. And failing to notify can also be the subject of a monetary penalty imposed by the Ombudsman of up to $250,000, and that would be on top of the fines. The other thing to bear in mind here is that in some instances, the officers of a company which has failed to notify a breach can be personally liable to be criminally convicted. Now, that is going to really mess with your life. These are very serious consequences. The flip side of that is that reporting a breach is not necessarily going to lead you to any consequences at all. If, as we said, breaches are not if, they're when. If you have taken appropriate measures to guard against the breach, and you have taken, measures to address the breach and address the individual harm, the Ombudsman may be perfectly satisfied with your response and also your original systems, and may go, thank you for reporting, stuff happens, move on. Or they may come back with a few recommendations, but they're not necessarily going to try and send you to jail, try and make you pay them loads of money. If you don't report when you should have reported, that will almost inevitably happen. I'm obviously in Cayman, I'm advising on Cayman data breaches, but a lot of times these are have an international impact, and certainly the financial potential consequences in the US and the EU are much, much bigger. For instance, the General Data Protection Regulation, GDPR, which is what prevails in Europe, provides that where an organization has committed a data breach, the regulatory body can impose an administrative fine of up to 10 million euros or up to 2% of a company's worldwide annual turnover of the preceding financial year, whichever is higher. So if you're Meta or somebody like that, that is an awful lot of money. So I said I was just going to run you through a few scary examples. And my favorite is actually Equifax, because it's, in a sense, in the worst possible sense, the gift that keeps on giving. So cast your mind back to 2017, which is when Equifax lost the personal and financial information of about 150 million people. Not a small data breach. And that happened because of, and I quote, because I have no idea what this means, unpatched Apache Struts framework in one of its databases. They actually failed to fix the critical vulnerability months after the patch had been issued. And then they failed to inform the public of the breach for weeks after it was discovered. So pretty much as bad as it gets. They knew there was a fix. They hadn't applied the fix to enhance the security, and then they did not report and they did not reach out to the individuals. I mean, can you imagine, how this is all your credit information, that's been out there for weeks, how damaging that could be. So in July 2019, they agreed to pay a $575 million fine, which had the potential to rise to $700 million. And that was in a settlement with the US Federal Trade Commission, Consumer Financial Protection Bureau, and all 50 United States and territories in the United States of America. They'd already paid US 625,000 in the UK for the breach. And that at that time was the maximum fine that could be levied. As I've just told you, GDPR has really upped the ante on that. So if this happened today, that would have been a lot more money. But it doesn't end there. In 2020, Equifax was made to pay further settlements relating to the breach of 7.75 million plus 2 million in legal fees to financial institutions in the United States, and 18.2 million to the state of Massachusetts, and 19.5 million to the state of Indiana. So yeah, all in, that probably did come to somewhere around 600 million for that breach. And there's still a few lawsuits ongoing, so it may not end there. And the reason I like this as an example is not only because, the facts of the example are pretty egregious, but it really demonstrates how this isn't a kind of one and done. This will roll on. And, if they were paying 2 million in legal costs to one of the people that they settled with, only imagine what their legal costs are, and only imagine what their administrative costs are. So, it really is an absolutely huge thing. I think I'll just, touch on another one. And this is more recent. So this is January 2022, and it was Morgan Stanley. And this was, what is interesting about this is actually more focused on the civil side of things. So they paid already a 60 million penalty to the Office of the Comptroller of Currency. And what they failed to do was exercise proper oversight of the 2016 decommissioning of 2 wealth management business data centers located in the US. They failed to effectively assess or address risks associated with decommissioning the hardware, failed to adequately assess the risk of subcontracting the decommissioning work. So remember, I said you're responsible for your third parties too. So they farmed this out. Somebody'd messed it up. It was Morgan Stanley who ended up paying the fine. And they did not exercise adequate due diligence in selecting the vendor. They didn't monitor their performance, and they failed to maintain an appropriate inventory of the data that had been stored on the decommissioned hardware devices. That had happened in 2016. They managed to repeat it all in 2019. So they've dealt with the regulators, they've paid their fines, but then, this being America, of course, out of the woodwork comes the class action claim for all of the individuals who are affected by this. And essentially, long story short, that was another $60 million to settle that particular piece of litigation. And Morgan Stanley's public statement on all this: we have previously notified all potentially impacted clients regarding these matters, which occurred several years ago, and we are pleased to be resolving this related litigation. No shit. So that is pretty much what I wanted to say today. I think we've got some time for questions, but thank you very much for listening. Ooh, silence. I like silence. Oh, and there's hands up at the back too.
Hi there, thank you very much for the presentation. Can you confirm that Cayman Islands law firms that house KYC data are subject to reporting to the Ombudsman?
Yes, I mean, well, reporting if there's a breach, yeah. You don't, I mean, there's no registration process or anything like that. You don't have to go, oh, I'm holding data, please make a note. But yes, if you're a law firm is an organization. KYC is personal data. Some of it may well be sensitive personal data, probably is if it's a passport or something like that. If there is a data breach and somehow that information is lost, destroyed, unauthorized access, you absolutely have to report that breach.
And do you have any examples of any Ombudsman fines in Cayman?
So the Data Protection Act in Cayman came into force in 2019, and obviously in 2020 we all had COVID and working from home and all this kind of thing. So the Ombudsman has been more in education mode than enforcement mode, but they are now in enforcement mode. So to date, there has not been a lot of history of prosecutions and fines. There's been a lot of work going on with the Ombudsman in terms of ensuring people are aware. The Ombudsman now feels like you should all be aware. And so moving forward, I don't think there's going to be any level of tolerance that you don't know what you were supposed to do, when you were supposed to do it, or how you were supposed to do it.
Thank you.
Hi, question. I'm next door to him.
Oh, right. Hello.
Yeah, so you spoke a lot about the Ombudsman. Do you have any experience or have you seen cases with SEMA as it relates to cybersecurity breaches? So I know the Ombudsman would be the regulator for data breaches, but SEMA for regulated entities. And SEMA has been very vocal that this year they're going to be focusing on cybersecurity in their prudential inspections. What have you seen, heard, or have you seen cases where SEMA has made findings and in that nature? Just curious to know.
I haven't seen much of that yet. And it is, as you say, something that they have announced over the last year that they are going to focus on. I think, frankly, they've had their hands full focusing on KYC and trying to, get themselves off up to speed so we can get off various lists. So I think it's early days on that. I only have a couple of anecdotal sort of feedbacks, if you like, from people I know who've been through a regular SEMA inspection, and all they were really asked to do was, do you have a cybersecurity policy? Can you give it to us? And so forth and so on. So I don't think it's got much past that at this stage. But you're absolutely right. That's going to be coming up on SEMA's radar. And I mean, that's an entirely separate thing to data protection breaches. But yeah, it's going to be watch this space, and you might find yourself, and I think it's also it's going to be different criteria as far as I read it. So you're going to have to find yourself going again. Within 5 days, I need to know what happened. I need to figure out if I need to report here. I need to figure out if I need to report here, and I'm sure there will be more things to think about as well.
Thank you.
Did you want the microphone?
Okay. So I'm from Jamaica. We're actually going through an exercise right now because our Data Protection Act was passed in 2020, and it's
Oh,
going to
right.
be implemented, or I should say enforced, December 2023.
Okay.
People will have to get data privacy officers
Right.
and other compliance measures. But I'm going back to one of the slides which you said where a report would have to be made to the ombudsman if there was, I hate to say, a, a breach that actually
Yeah.
like endangered people, not like he sent an accidental
The
email
rights and freedoms that are
and
protected,
recall.
yes.
But it it occurs to me that maybe I don't know what the situation is in Cayman, but I can tell you, like in Jamaica, there it should be a material difference between breaches by government or large organizations rather versus those by small ones. I'll give you an example. For instance, we had our Jam COVID, which was exposed on an Amazon S3 bucket for the world to see for PII. We had a conglomerate that had again got locked by ransomware, and nobody knew until somebody dropped it on LinkedIn as such, and no notifications to anybody. And yes, these are large organizations that collect a lot of information, but for the small business person as such, um, in Cayman, are there different ways of, for instance, maybe for breaches doing more in an education mode or in an assistive mode rather than an insistive punitive mode for those people? Because for instance, the fines in Jamaica is 4% of your earnings. I don't know what it is in Cayman, but I'm assuming it is of similar size.
Well, and to your question, I mean, that all feeds into the word appropriate. So let's see if I can make this thing go back. Okay, so the key word for large organization versus small organization is what measures are appropriate. And that is where this you may not be held to the same standard if you're a small company and a bunch of people's emails somehow are hacked. Doesn't mean you don't have to report. You're definitely going to have to report. But when the ombudsman assesses whether your measures to protect that information were appropriate, they will take into account size, resources, those sorts of things. And as you rightly point out, if you are a large multinational organization with a branch in Cayman or Jamaica or whatever, the measures that are going to the ombudsman or your regulator is going to think would be, if your legislation is the same, appropriate, are going to be a lot higher. And but that's the only get out, if you like. And it's a risk-based analysis. I mean, I know we all hate risk-based analysis because we do it with KYC and AML and all this thing. And it's always like, okay, well, we did our risk-based analysis, and then somebody comes along and tells you that your risk-based analysis was wrong. But that's all you can do. You there's and I mean I don't know what resources you have, but if the legislation, as it probably does, has the same 8 principles, I would thoroughly recommend the Cayman Ombudsman's website and the guides on it for what to think about, and particularly in the 7th principle, the security and integrity mode, how to go about your risk, what factors to take into account. And that's where you just get that measure of, can we hold, the one-man band to the same standard as Google?
Right. So I can tell you the principles are basically the same. Problem that a lot of confusion in Jamaica is because we have the law, but we really don't have the regulations,
Right.
like how they're supposed to be, interpreted. So that's where our issue is.
Right. And, obviously, you're not going to be able to 100% rely on anything that's come out of, the UK or Europe or Cayman in terms of guidance or so forth. But if you are an organization trying to comply in Jamaica at the moment, at least if what you had an issue and you said, well, hey, we had the legislation, but we had nothing else to go by. So what we looked at was these other sources, which all have the same concepts as our legislation in order to carry out our risk-based analysis. You're going to have a conversation with your regulator that's going to make some kind of sense. I think we may be uncannily on time. Thank you, everybody.